Okay, in part two of the civil liberties presentation here, I'll walk you through the highlights and lowlights of the remaining amendments in what we now know as the Bill of Rights, excluding the 10th Amendment, which is an amendment related to federalism that we had talked about previously in that unit, in that chapter. Okay, the Second Amendment. It's a standalone amendment. There's its entire language right there in front of you. Um, in our recent political debates over what it means or what it doesn't mean, there has been over focus on the second part and a complete ignoring, and oftentimes in the literature, particularly by those advocates like the NRA, you won't even see the first part regarding a well-regulated militia. There's not a lot of scholarship on what the founders intended, mostly in I say mostly, like I know, the assumption is that there wasn't a whole lot of controversy in what they felt the language meant. Some scholars seem to think what they were talking about and why it sits by itself and not part of the First Amendment, or part of Amendments 5, 6, or 7 for that matter, was that it was a protection designed particularly for the states who were doing the militias at the time, and the militias are critical to the operation of this country militarily for a century and a half. And a lot of them were doing it on the cheap by having the militias made up of volunteers who kept their weapons at home. And there was some fear on the part of states that the U.S. government, the new U.S. government, using its military powers in Article 1, Section 8, might demand certain restrictions, requirements on that, and they wanted it written down that no, you could not interfere with the current militia processes being used by the colonies slash states at the time. There's almost no Supreme Court judicial history on the amendment until the 21st century. One of the rare cases came up in the 30s over forbidding sawed-off shotguns as part of a federal law. And it was because it seemed to have been the weapon of choice of the bootleggers slash gangsters that arose out of Prohibition. And the court upheld it. The court upheld the restriction. Whether, and I don't have enough knowledge of the case to say they were doing so justifying it as a commerce clause, or they were doing it justifies as enforcing the Prohibition Amendment, both of which would be constitutional powers, but even then it would have to be acceptable to the Second Amendment. When it becomes an issue constitutionally is in your lifetime. In 2008, the court issues a 5-4 ruling saying that the right to bear arms is a right possessed by the individual, not the individual as part of a militia. That was an important first step, but it was limited by the fact that it was the federal territory, the District of Columbia. 2 years later, the McDonald v. Chicago decision extended it to state and local governments. So now whenever a state, think Connecticut post Sandy Hook, passes increased restrictions on gun ownership, somebody doesn't like it, they take it to the court. The court now has to consider post 2010, does it jive with the Second Amendment? I want you to keep in mind, no right on the Bill of Rights is absolute. We just went through that with the First Amendment. None of those are absolute. You don't get to practice any particular religion you want, at least in terms of things like human sacrifice. Limits are allowed. So that leads to that last point. It's still a political question. And states like Sandy Hook after that shoot, or states like Connecticut after the Sandy Hook shooting, ginned up their restrictions tremendously, and many have survived. The court still realizes this is a hot political issue, and I'm sure the Supreme Court, even with the 2 additional sort of conservative justices put on by Trump, would really like to avoid this and hope that the political process works out. Maybe to some degree they might be regretting the hornet's nest they stirred up by issuing the McDonald ruling. We'll see. I mean, with 2 questions, what they're going to pull upon. This is certainly something that has been a part of your lives, so it's an area that you should have some passing knowledge about the political aspects of it, and there you have the court decision aspects of it. Now, I've completely ignored the Third Amendment. The Third Amendment requires that if the government uses your private property, your homes, to house troops, that you can expect compensation for it. It obviously hasn't been an issue for a long, long time, and we don't really have the time to talk about scenarios where it could rise up again. That just happens to be the Third Amendment. You see the slide after the next slide in the sequence deals with the Fourth Amendment. And just a word on amendments 4 through 8. The colonists, now Americans, were very sensitive to the way the British government had used the criminal justice system as it existed in the 18th century to impose its political will on the people. So the bulk of the Bill of Rights are various requirements on this now new national government, the government that in their minds was taking the place of the British government, giving them set requirements as how the judicial system would work, how the criminal justice system would work. Remember, until Barron versus Baltimore, well, I mean, not until Barron versus Baltimore, as a consequence of Barron versus Baltimore, both before and for nearly plus a century later, this only applied to the criminal justice system carried out by the federal government. You saw in the previous video and in the PowerPoint that hopefully you have, the series of cases that, just like with the First Amendment, one at a time extended those requirements to the criminal justice system of the states. And now, with a couple of minor exceptions that I'll talk about when we get to it, they all now apply to all criminal justice systems in the United States. So the first one is the Fourth Amendment. And I want to say they were called writs of assistance. These were sort of blanket search warrants where the Crown would just authorize royal authorities in the colony of Massachusetts to search, search wherever you want, whoever you want, for whatever you want. So they were obviously, the colonists were very sensitive to this issue. So this sets forth before the government, as part of the judicial process, as part of the criminal justice system, can search through your stuff. This is the requirement that they must go through, and it intermingles branches. The one sort of not mentioned is the legislative branch. First of all, they have to be investigating a legitimate crime. So the legislature had to have made a constitutional law making something a criminal offense. That's where you get the first requirement there that you see in the amendment of probable cause. The executive branch that is executing the law must demonstrate probable cause that you have violated this legislatively passed law. We get the third branch in because they don't justify it to themselves. They have to go to the third independent branch, the judiciary, and present, here is why we think citizen so-and-so is involved in breaking this law. They have to convince the judge that there could be a chance that you broke this law. And searching in this place for these things is how they're going to prove it. So that's the second thing. They've got to specify the location of the search. They've got to specify what they're searching for, and that the third part has to be certified by that independent judicial branch. So there are the three components. Demonstrate, have probable cause, be specific in what you are searching and searching where you're searching, and then have that statement legitimized by an oath before the judicial branch. So if the police lie, they make stuff up, they now have committed perjury. They've committed a criminal act. If you have all three of those, you obtain a search warrant. So we're going back to the first bullet there. which is permission for the executive branch to violate your personal property in restricted, limited circumstances. So if we were in a class, the next thing I would do would ask, are there instances when law enforcement can search without a search warrant? Those of you in criminal justice would know the answer instantly, yes indeed. Or if you looked ahead at the slide, you would know. Well, you already know. If you are being arrested, they've caught you red-handed doing something, or they are searching an arrest warrant, they can search your person, your pockets, etc., your bags, um, as long as they're open, or areas immediately within your control with no search warrant. And that's part of protecting the safety of the officers and you in the process of an arrest. Cars is always a hot topic. The general rule of thumb is don't have anything in your car that's illegal and think you're going to get away with it. You get pulled over, hope that they don't find anything. Generally speaking, the scales are tipped in favor of law enforcement in terms of searching a car, any part of the car. The last one is plain view. Obviously, if they see something that's illegal, see something related to a crime, they don't need a search warrant. And this also applies if they have a search warrant for one crime, and in the process of legitimately exercising that search warrant, find evidence of another crime. They don't need to go back to the judge and get a new search warrant, as long as if it's in plain view. The old saying I use, if they're searching for a stolen elephant and they go into your closet and start opening up shoe boxes, and in the process discover counterfeit money, that might not be an allowed exception. They would have to do some pretty good arguing over that. Now, this third slide on the Fourth Amendment, is where things get a little tricky. What happens if they are using evidence, attempt to use evidence that was obtained either without a warrant at all or without a proper warrant? Okay, good question. We go more than a century before the court really even bothers to address that. And you've got to remember, until we get well into the 20th century, federal law enforcement is not doing much searching. So there probably wasn't a great deal of need for it. However, over 100 years ago, in the case of Weeks versus United States in 1914, the court establishes a rule called the Exclusionary Rule, that if you attempt to use evidence not obtained with a proper warrant, and obviously if your defense finds out about it ahead of time, you can stop it from being used in the first place. If it is used and discovered after your conviction, it could be a very important way to get your conviction thrown out, or at least that conviction thrown out with the expectation that a new trial would have to proceed without that evidence at all or anything related to that evidence. Oftentimes that means you're free. Now that sat there and it applied only to the United States government. In 1949, in Wolf versus Colorado, as part of this incorporation process, the court established this principle that the Fourth Amendment had to be followed by state and local government too, which is doing the bulk of law enforcement. However, they neglected to include the exclusionary rule. They just kind of assumed, silly perhaps, that the states would go along with it and just use the exclusionary rule. The states did not do that. And finally, 12 years later, in the Mapp versus Ohio case, they say, okay, now the exclusionary rule must be followed in state courts as well, which is where predominantly most criminal cases are heard. Now, a lot of pretty bad, not a lot, it's not like thousands, but some pretty bad characters were released or never convicted because of what turned out to be rather minor issues with search warrants, the wrong date, the address off by one, some things that were pretty minor and technical, but did not follow the letter of the Fourth Amendment in terms of a search warrant. And the case of U.S. versus Leon, the court created an exception to the exclusionary rule. And Lawyers who defend criminals don't like it, don't like any exception to it at all. But I think the court was in one of the rare instances kind of addressing public outcry and perhaps an amendment or federal law or some laws could be changed to reduce the impact of the exclusionary rule. So they said if the violation of the Fourth Amendment was something minor. It had no, it was, let me put it this way, it was not the law enforcement's mistake. It was, in one case, there was an address issue. It had to do with the surveyor's office not doing the map right. The police did everything they were supposed to do. In another case, the judge had written the wrong date because he was issuing the warrant in the middle of the night. It wasn't anything the police did. It was something outside the span of control of the police that you could bring it up. You could say, Your Honor, we object to this evidence and it should be excluded. And then you would have no jury there. You would have a whole argument as to whether or not this exception under U.S. v. Leon applied. If there are three others that you see there. Well, that one was the good faith. That's the good faith mistake. The police operated. They did everything they were supposed to do. They operated in good faith under the Fourth Amendment. The one before it is if you could demonstrate you would have found it anyway, somehow, some way, it's probably the least effective of it, then it could also still be used. And the final one came up a few years later out of Arizona or Kentucky, I think it was Kentucky, where a police officer is behind a car, I think a tail light is out, something minor, and they put the license plate in, and it comes back that there's 27 unpaid traffic violations out on this person. There's a bench warrant, so they pull them over, and they're not going to probably slap the cuffs on them, but read them the riot act. So he pulls over, walks up, window comes down, looks into the car, sees a gun half sticking under the front seat, and asks the guy, "Do you have a permit for the gun?" And the guy doesn't. Not only does he not have a permit for the gun, but he's a felon on parole. And he's not supposed to. He can't even get a license for a gun, let alone have one. So he's violated his terms of his parole. He's going to go back to jail. So in the course of litigating this case, it's discovered that he had paid all the parking tickets, and there was a problem with the data entry updating the information system that the police used. So in this case, it was technically law enforcement. It was their database, but the court extended the good faith to an honest mistake. This wasn't anything that the officer did. This was something clerical, something minor. So collectively, all of these from U.S. v. Leon after drive criminal defense attorneys nuts. They probably don't go far enough for prosecutors, but they are where they are. Okay, remaining on the Fourth Amendment. Next thing, what about your bodily fluids, i.e. drug testing? Is drug testing a search? Yes, indeed. Obviously, it can be carried out with a search warrant. You can get a warrant to search for the existence of drugs in your system. Now, absent of that, what about random drug testing? First of all, if it is a private employer, that's between you and them. If they have a random drug testing program, they make you aware of that ahead of time. You take the job. It's part of the job. As long as they are not discriminating in who they give the random drug testing to based on race, religion, ethnic origin, etc., that's a matter for you to decide. I don't want to be drug tested, so then I don't take the job. I'll go to a job where I don't get drug tested. Government employees, well, obviously this is the government itself. The courts do allow it if you are in a position of public safety. Generally speaking, it has two rules of thumb. If you carry a weapon, obviously public safety, they would prefer you not getting high and shooting people with it. Or you're in the food safety, or you're in transportation safety, air traffic controllers, etc. There are probably other sensitive positions too that we don't know about because you have access to sensitive information. Not like they think you're going to get high and reveal the information. They worry that some foreign enterprise would find out you have this addiction and use it as a way to manipulate you. Then another issue came up a number of years ago was high school students. What about, I mean, those of you who attend public schools, could you be random drug tested? Oregon started a program issuing random drug tests to student athletes. And it went to the Supreme Court, and the Supreme Court, I mean, people thought the Supreme Court were going to rule this unconstitutional, and they ruled it constitutional. So at least from the Supreme Court's point of view, it applies to anybody engaged now, not just being a regular student. You're sitting here and, well, you know, not here in class, but if you're in class and all you do is go to class, you cannot be subjected to a random drug test. But if you participate in any extracurricular activity, sports, the band, etc., it is not constitutionally prohibited as long as it's equally applied to anybody. It is indeed random. There's no discrimination in the drug testing. You can choose, like the private person choosing not to work, you can choose not to be in the band if you don't want to subject yourself to the drug testing. Given the appointment of Gorsuch and Kavanaugh to the court, I don't think that's going anywhere anytime soon. There are, however, politically, the reality is very few school districts have chosen to do this. And we will see. I mean, think about this. Will there be once we have a better testing regime, will there be mandatory COVID-19 testing before you can go back to school in the fall, before I could go teach? We'll see. I don't really even want to think about that. Don't know why I brought it up. Okay, finally, search warrants and electronic communication. You see there on the slide, to this bookend case is Olmstead in 1929 when the issue first came up. Do you need a search warrant to tap into people's phones? And the Supreme Court said no. It's a phone that you're using through a lease. The information is traveling over wires through public property licensed by the federal government to another phone leased through an organization licensed by the federal government. Therefore, assume any phone call you make, the government's listening. Finally, in 1967, the rise of the civil rights movement and civil liberties movement, all these criminal protection cases, the Katz case overturns that and says, yes, now you need a search warrant to tap into somebody's electronic communications. Of course, at the time, it was old-fashioned telephones on a wire. Post 9/11, we get the Patriot Act, and there are now many issues to be worked out. One of the first things that was allowed for is something called a roving tap to deal with cell phones, etc. They don't tap a particular phone or a particular phone number, they tap a person. We get a search warrant to tap into the electronic communication of this bad person, and here's our probable cause, and this is what we're listening for, and this is why. And whatever device, they borrow somebody's phone, there's a public pay phone, their cell phone, a burner phone, whatever. Other issues that arose was the claim in the passage of the Patriot Act that American phone calls weren't being tapped into by the government. Eric Snowden skedaddles out of the National Security Agency with information that that's just not true. Another aspect that has come up is metadating, data mining through phone calls. Instead of listening to them, just looking for patterns, looking for red flags in terms of particular numbers called, doing that via computer, and then the red flag would be brought up and say, okay, do we have enough justification to now tap whoever is making these phone calls? That is, as far as I know, and I don't think Trump's going to do anything about it, is the procedure. Obviously, the Obama administration pulled back on that, but not entirely. Then you had the whole idea of your information being exposed via Facebook, and the government trying to figure out a way, how the heck do we deal with this? They're still trying to sort that out. And the 2016 election and the hacking of information systems. It is a brave new world that the Supreme Court hasn't even, the law hasn't even caught up with yet, let alone the Supreme Court. So there's not a lot of guidance there other than, yes, in terms of traditional electronic communication, search warrants do need to be there. So if you are a domestic person engaged in a pretty mundane crime using fairly traditional methods of communication, the government does need to get a search warrant. We start bringing in terrorism, international things, it gets much hazier as to whether or not you need a warrant at all, or whether this warrant could potentially be done by something called the FISA court, which does warrants in secret. Um, Again, it's the world you all live in now. Welcome to it. All right, now I'm going to walk you through in the next two slides the two big, we'll call them trial amendments, that deal with various aspects of what a proper trial should be. Go to that slide and notice how the bulk of them through the 60s into the early 70s were incorporated to the states. So while initially these expectations were on trials in federal court, these are now expectations on virtually all trials. We begin with the Fifth Amendment. And having said that, the first one is in Burgundy because it hasn't been incorporated. A layer of process that takes place before you are put on trial is an indictment, an official accusation. The federal government must go to something referred to as a grand jury. It's not very complicated why it's grand jury. It's bigger than your typical 12-person jury, oftentimes 24 or more citizens who sit and hear multiple cases. They don't sit one case at a time. The prosecutor goes in, the U.S. attorney goes in and says, here's what I've got. They don't necessarily reveal everything they have, but they have to convince this group that it's enough to put you through the hassle of a trial. If they make that case, then you are indicted, and we begin the process of a regular trial. It has not been incorporated. States do not have to do this. Virginia does not do it. The prosecutor, what we call the Commonwealth attorney, goes to a judge and convinces the judge there is enough reason to issue an indictment and go through with the trial. There are states, though, that do have grand juries. It is generally perceived as not a great protection. There is an old expression that a prosecutor can get a grand jury to indict a ham sandwich, that they tend to defer tremendously to the prosecutors. So that one's there. It has not yet been incorporated. It then, in the unhighlighted part, talks about the fact that the military operates under a separate judicial system established by Congress, justified in Article 1, Section 8. Now, nor shall any person be subjected to the same offense to be twice put in jeopardy. This is referred to as your double jeopardy protections. If the case has proceeded far enough, there is the expression that jeopardy has been attached. So at that point, if you win, the case gets thrown out or you get found not guilty, you cannot be put at that level on trial again for that crime, period. That is both the federal and state level. Now, two different levels, two different crimes. If you murder somebody, you have violated the state law against murder, and that law was created under their police power. You also now, post-1964, have violated their civil rights, because if you recall, your first civil right is life. So you could be found not guilty for whatever reason in the state murder trial, but then the U.S. attorney could come, slap the cuffs on you, and put you on trial in federal court for denying that person their civil rights, the right to life, and could be potentially convicted of that. That is not double jeopardy. That's two different crimes and two different levels. Being compelled to be a witness against yourself. Law enforcement for nearly 2 centuries was not overly concerned with slapping you around a little bit to get information and or confession. And this was becoming more relevant and more frequent into the latter half of the 20th century. It is what motivated the Supreme Court to issue the Miranda warnings, that we are tired of having to deal with these cases time after time and parse through detail after detail. So we're going to set a standard to all you law enforcement people. If you read them this and they still decide they want to blabber away, good. If you don't read them, their rights, and you get information from them, not good. So now we are very much accustomed to that first expression in the Miranda warnings. You have the right to remain silent. The only thing you have to do is identify yourself. And lawyers would say at that point, shut up. Don't say another thing. At some point in the process, they will consult with you and say whether or not it would be worth you to testify. 9 times out of 10, they're going to say no, because you don't just get to answer their questions, you're going to have to answer the questions of the prosecutor. Um, Due process of the law is a requirement that was reiterated in the 14th Amendment. Again, we talked about the difference between procedural due process, whereas are the steps being followed, um, versus substantive due process. Is the substance of the law fair? Um, that's for another segment, perhaps not perhaps, in the final video on civil rights. The last one's referred to as the takings clause. And I think it gets shoved into this judicial set of amendments because there was an assumption that what you got compensated, how much money was paid when your property was taken, would oftentimes be litigated. Um, the government would come in with some low number, you would expect some high number, and off to court you would go. So you do, if the federal government and now state governments take something of value of yours, they take part of your land to put a power line through Haymarket, you are guaranteed compensation. And you are guaranteed a judicial process if you don't feel that compensation is fair. So that's the Fifth Amendment. Okay, the Fifth Amendment was largely about considerations that should be given to you before the trial begins. The Sixth Amendment focuses almost exclusively on how the trial must proceed. You'll notice the first one, and you notice all of these have been incorporated. The first one, you have a right to a speedy and public trial. Speedy is always in the eyes of an appeals court in terms of the defendant. Um, the state doesn't get to demand as much. They have a much harder time being granted delays than the person on trial. Remember, this is about protecting the right of a fair trial for the person on trial. Public trials, none of these secret star chamber type cases that were common in Europe. All courtrooms in this country, except for juvenile court, is open to the public. You want to kill a free day, sometime when we're actually free to go about again, go into Manassas and go to the courthouse and watch a couple of trials, all the way up to the Supreme Court. You get to a place like that, you're going to have to wait in line. You get to appellate courts, you better be excited by the arguments of lawyers. The trial courts are going to be witnesses, and they could be, quite dramatic, and you might even see somebody you know. An impartial jury from the state and the district wherein the crime has been committed. The prosecutors can't hunt around for a judicial district that they think will be to their benefit. The trial has to be where the crime was committed. The defendant can make a case that they can't get a fair trial in that particular jurisdiction. They occasionally win, but more often than not, they don't, because the expectation in the selection of the jury, you will find eventually 12 people, whatever the number required for the particular case, particular state. You can find 12 that will be impartial. Now, if you want to see a movie about the rise of the use of jury consultants, or a television show, I have never seen it, but there's this CBS show called Bull. There's a movie based on a John Grisham book called The Runaway Jury. And it talks about how the state and or wealthy people involved in cases tend to have the ability to hire very sophisticated jury consultants who will assist in deciding who gets eliminated or who doesn't, to try to skew what should be an impartial jury in your favor. It's sort of sabermetrics for trial courts. Obviously, everything related, this is something in legal terms referred to as discovery. Everything related to the case, all charges, all evidence, etc., that is going to be used against you must be given to your attorneys ahead of time. If that is done in not a very timely manner, they can object, and under that provision, potentially have the information denied or the trial delayed to best study this new evidence. Be confronted with witnesses against you. Your attorneys have a right to cross-examine witnesses against you. You have a right to compel witnesses to appear, to be questioned, even they may not like you, to provide information which could help you. That's the compulsory process for obtaining witnesses. Now, a couple of sensitive issues here. One are children in abuse cases. Some states have established processes, and they have to be very careful constitutionally how they do this, where the child is in a different room on a split screen TV, so that they don't have to be in the same room with their abuser. Videotaping ahead of time I don't think is allowed, but I believe most of these type of systems have been allowed. Another related matter is rape cases, and one of the arguments for why rape cases aren't prosecuted as much is that the accuser has to testify, and this can, I mean, we don't even need to get into the realm of issues that this causes. A case that came up recently had to do with all this stuff you see on CSI. Do the scientists who actually do the test have to be there, or could the director of the program be there? And it was kind of iffy which way the court may go, but the court ruled that in order to achieve this right, that the person who did the test could be required to be there in person to give evidence to the validity of a particular CSI type test. And then the final one has to do with the topic of what I hope you watch, the Gideon movie. The system in the eyes, and this was in the early 1960s, had become so complicated. The notion of a private individual being able to represent themselves was silly at this time period. And for the whole system to be fair, you had to have an attorney. Now, we have litigated time and time again over the past decades how good an attorney. And the court has been reluctant to set some sort of, well, you've got to be this good. If you're an attorney in the bar, the notion is to have passed law school and passed the bar and be admitted to the system. That's it. And if you're still somehow got through that and are a doofus, then sorry, you got a bad lawyer. And the fact that Ford Motor Company, or I can't think of his name, Harvey Weinstein, can hire the best troupe of lawyers possible, and you can't. They're all lawyers anyway. And we could debate endlessly the fairness of that process, but at least post Gideon, now everybody will have an attorney by their side. And that's why I wanted you to watch the two trials and see just how different. Granted, they boiled them down for the purpose of the movie, but you could see just how different the circumstances were for him without a lawyer, where he did the best he could. He did surprisingly well for a man of his education. But then afterwards, when he had a lawyer who knew what the heck he was doing. Now, we've skipped the Seventh Amendment because it has not been incorporated. It is a right to have a jury trial in a civil case where the money involved is more than $20, which was a lot back in 1770 or 1791. So that means in all likelihood, if you're going to have, not in all likelihood, you will have a jury trial in virtually any civil case in the federal courts. This is where Smith sues Jones. It's not a criminal matter. It is up to the states when it comes to civil matters in their jurisdiction as to whether or not to have a jury. The lawyers involved tend to sort of fight it out as to what circuit is if it's a technical case, that the only way to really have it understood to your benefit is to have somebody with, like a judge, then you're going to want a bench trial. If it is a emotional situation that involves gathering people's feelings to your benefit, then you're going to want a jury, not a judge. That is still hashed out state by state. So you do not have a right to a jury at the state level if it's you suing your neighbor over where the dog pooped. Now, the Eighth Amendment, two aspects of it. The first one is bail. Bail is a deposit on your body, a promise that if I am released to help my legal team develop my defense so that I have a fair trial, I am giving you this money as a deposit on my return on trial day. The amount has to be related to a combination of the severity, but not just the severity of the case, but the likelihood of your fleeing. Now, the notion is the more severe your case, that you could be put to death or you could be imprisoned for life, the greater the motivation is for you to flee, so the higher the dollar amount is to prevent you from fleeing. We'll see. One of the reasons, way back in the OJ trial, one of the reasons why he was denied bail was while he was riding around in his white Bronco, he had a false passport, a disguise, and a plane ticket to somewhere in Central America. So he had clearly demonstrated an intent to flee. In this case, he was hoping before his arrest. The last one has to do with obviously the death penalty, what has become known as the death penalty, or just isolated on the death penalty. We were making heavy use of the death penalty. I watch a couple of British shows, law enforcement shows from the time period is the 1950s, and I swear to God, they're hanging one person after another. So it wasn't just the United States of America. Early in the 1970s, the court got a case out of Georgia, and they are getting bombarded with these challenges to the death penalty, and they look at the country and the application of the death penalty across the states, and they are just seeing a mess. Different crimes that it's being applied to, not always murder, processing that is vastly different, and they're looking at this and say, you know what, the Eighth Amendment is a national amendment. This protection against excessive punishment or unusual punishment should be a national standard. So they just shut the process down. They issued a ruling ending all death penalty to that point, and commuting automatically anybody who's been sentenced to death under what they judged as an incredibly horrible system up to that point. They, in their decision, laid out some guidelines for if you're a state and you really do want to restore the death penalty, this is what the process should be. There's basically two main elements to it. One is, with the possible exception of the federal crime of treason, you're going to have taken a life. As bad as a serial rapist may be or a child abuser may be, that's not going to survive current Eighth Amendment interpretation. The other one, the decision whether or not to execute somebody, has to be a separate phase in the trial. So you are convicted in Virginia of a murder eligible for capital punishment. Done, we take a timeout. The jury comes back, they have made that decision is done. There is now what's referred to as the penalty phase. Given the circumstances, and we're not now arguing over whether you did it or not, that conclusion has been raised, but now that you have done it, you have done this particular murder, does this particular murder, who you were at the time, who you are now, who you might be in the future, merit death, the ultimate punishment, or life in prison? So states who began, and the federal government that began restoring the death penalty, had to establish a second process for the jury to go through to make the decision on whether or not to institute death as the punishment. Now, in this case, you're going to be in the witness box. I mean, it's not about incriminating yourself. You're trying to explain yourself, justify why they shouldn't put you to death. There's going to be a lot of tears shed. The victim's family is going to be brought in. And it's not, I would imagine, a pleasant circumstance for a jury to be on. But that's the current process. More politically right now, something referred to as mandatory minimums. They have largely been done away with, courtesy of President Trump, in cooperation with a bipartisan Congress. And that's whereas if you do this drug crime, the minimum you get is 20 years. You don't get to rationalize that was my first offense or whatever. And also related to this is something called the three strikes law. Your third felony you're now life in prison. Those have largely been done away with politically, not judicially. Um, so that's it on the Eighth Amendment. Again, we could go on for days and days and days on death penalty or those other related issues, but that just sort of summarizes where we are in the Eighth Amendment. And finally, the Ninth Amendment. You see the text right there. I'm going to paraphrase what the text says. Our listing, us, the first Congress, in creating our pseudo Bill of Rights, our listing of these particular rights should not be interpreted by those of you who come tomorrow or in 200 years to mean that's the list. There are no others. We are on Mount Olympus, and we, the gods of all, have determined these are the only rights Americans will ever achieve through a Bill of Rights. There are still rights that you have, period, with no Section 2 describing how do we come up with those rights. Now, so how do we come up with those rights? I think they didn't bother to put it there because they would have said, see the Constitution. There is an amendment process, and certainly in terms, in particularly big time voting, we have used the amendment process to extend accessing democracy through the vote as almost part of our Bill of Rights. Um, we could have chosen to talk, and there have been people who talked about an amendment to do healthy living in terms of health care and material wants, the whole freedom from want thing, add it as an amendment. But they didn't do that. They didn't specify a particular process. So how have we added? We've done, obviously, accessing democracy as one. Then we fast forward to the 1960s, and the Supreme Court steps in the absence of an amendment. They get a case out of Connecticut having to decide whether or not accessing contraceptives is a constitutional right that Connecticut, by forbidding it, is violating. So they ponder this and they decide, there is a Ninth Amendment that says there are rights not listed, and there is a Fourth Amendment which puts all this burden on the federal government before it, or any government before it messes with your belongings. So we're going to assume from that rises this notion of privacy, that you have a right to privacy. Don't look at my stuff. Don't interfere with my life without just cause. And we, because there's no restriction on who can discover these rights using the Ninth Amendment, now declare in the Griswold case there is this constitutional right to privacy. You got to sort of put it with an asterisk in that it's not one listed in the Constitution, it's not one listed in a particular amendment. It is created out of a court decision in a particular circumstance. Now, it's not like they were going to be burning the Supreme Court in effigy for giving people the right to privacy. Most people probably think that's a good idea. Where they catch a lot of flack for is 7 years later, they use that right to justify particularly that first trimester control over the future of a pregnancy in Roe v. Wade. That the decision to allow that pregnancy to proceed, particularly in the first trimester, is a private matter for the woman, and the woman alone, not the father in addition. I don't need to explain to you, although it hasn't necessarily made the news as much in your lifetimes as it did in the first quarter century after the decision, that has created all sorts of political controversy. It gave rise to the evangelical conservative wing of the Republican Party. That Ronald Reagan, who went from a believer in privacy as a conservative, conserve the power of government, not necessarily being opposed to abortion, to latching onto it in 1980 and I'm your guy that will work to overturn Roe v. Wade. I may have mentioned to you in another slide that its position is tenuous. It's being poked and prodded from different conservative states with 2 new justices appointed by Donald Trump on the court. So Once we recover from our coronavirus crisis and things get back to something passing normal and the Supreme Court gets back onto its routine and they get another abortion case that which comes close to almost forbidding abortion, will they decide we're going to overturn Roe versus Wade and we're going to say this is a police power matter for each of the 50 states to come up with a solution on their own, and we're just going to have to live with the patchwork? Yep, that's federalism. And we are now done the Bill of Rights when it comes to civil liberties. We have but one remaining video on the issue of civil rights, which is in many ways, in terms of government, the dominant issue of government, at least constitutional government. So I'll be working on that one soon.